All right. Lastly, we mentioned earlier the Wisconsin. There was a big win for the, I guess, progressives, the left, whatever you want to call it, in the last election in Wisconsin for the state Supreme Court. Republicans or conservatives still dominate this court. I know it's nonpartisan, but give me a break. The guy who had recused himself in the question of the purging of like hundreds of thousands of voters, last time he lost the election, he's going to hear it again and not recuse himself because Wisconsin, because Republicans. Here is a Republican Supreme Court justice, Wisconsin Supreme Court justice, talking about the stay-at-home orders. Now, apparently, what's interesting that's happening in Wisconsin is that Democratic-leaning board of electorates, because they have the opportunity to call for a safe election by ballots, are doing so. And so there's a fascinating dynamic that's happening where these Republicans are saying, we don't want to do this. All right, don't do it. Good luck with your voters coming out in heavily Republican districts. But here is the state Supreme Court talking about how oppressive it is to have people stay at home during a pandemic, not because the government's not providing economic benefits to them to make up, but rather it's an encroachment on their freedom.
Counsel, because one of the rationales that we're hearing justifying the secretary's order in this case is that, well, it's a pandemic and there isn't enough time to promulgate a rule and have the legislature involved with determining the details of the scope of the secretary's authority. I'll direct your attention to another time in history in the Korematsu decision where the court said the need for action was great and time was short. And that justified, and I'm quoting, assembling together and placing under guard all those of Japanese ancestry in assembly centers during World War II. Could the secretary, under this broad delegation of legislative power or legislative-like power, order people out of their homes into centers where they are properly socially distanced in order to combat the pandemic?
Your Honor, Korematsu was an equal protection challenge to the action that the government took to address the crisis. This is not a substantive constitutional challenge to what DHS has done.
My question goes to the scope again of the secretary's authority and what the limits are. What I'm hearing is, well, the legislature doesn't need to specify the limits. It's a time of pandemic. There isn't enough time to go through rulemaking. So the secretary just has to do whatever she alone deems necessary to combat the pandemic. So my question to you in invoking Korematsu is not the bases for the claims that were brought in that case versus this case. The point of my question is, what are the limits, constitutional or statutory? There have to be some, don't there, counsel?
Yes, there absolutely are, Your Honor. Justice Bradley, I think if you read the petition for an original action that was filed with your court just last evening, there are a variety of fundamental rights-based claims that target different pieces of Executive Order 28 on the basis of the freedom of religion, the freedom to travel, and I don't know all what's in there. It's a long petition, but there's a lot of constitutional rights in it. That is one of the fundamental backstops against an unreasonable and unconstitutional exercise of power by DHS.
All right. Let me just tease out what is being argued here. She is citing Korematsu, which is the Supreme Court case that allowed for people to be put into internment camps without any type of legislative action. And she's saying, like, could, that was a problem. Could I don't know what the position is in Wisconsin. Could the health inspector, the chief health inspector there, say, we're going to quarantine people here? And the lawyer is saying, well, look, we made it quite clear that the limiting principle is based upon the constitutional rights that people have. And those constitutional rights, there is a huge body of law that says that you cannot abridge these rights without some type of compelling state interest that is consistent with the authority that's doing it. The health inspector cannot say people are going to go into internment camps because we're afraid that they're spies. Could the health inspector say that we need to quarantine people because they have Ebola? I think the answer is yes. I don't think there's any obligation for the health inspector to say, we're going to need legislation on this with these Ebola people. We can't quarantine them. I have no authority to do. Of course, there's authority here. It is completely consistent with the role of the state health inspector to issue something based upon health. And then I guess you could question, like people could petition and say, like, there's no health issue here. And then the court could resolve, like, there's no health issue here. I mean, it's just, these people are lunatics, and it is unbelievable how cohesive their lunacy is across the board. State Supreme Court. And now look, this is the same state Supreme Court that said that Evers did not have the ability to push the election in a pandemic. The same court that was then backed up by the U.S. Supreme Court that we're going to discount any absentee ballots that come in after the election day.
Which is a substantive violation. I mean, what strikes me, you outlined that perfectly in terms of just the insane disanalogy there, but that this stuff always runs in tandem. I don't know where the Bill Barr requests are right now for essentially doing away with habeas corpus. I don't know where that stands. We do know that the Wisconsin Supreme Court, as you said, basically just, essentially mandated that, hey, if you want to vote or exercise your franchise, you have to put your life in danger, and we're not going to do anything to mitigate that. So it isn't even, and of course, we're not going to do anything on policing issues or anything else. That the parallel of, we will use the most extreme rhetoric, we will use the most insane, ludicrous historical comparisons to try to not do anything to mitigate a pandemic, and then that will go along this other track of us actually relentlessly undermining substantive civil liberties and voting rights across the board.
All right.